and welcome to what is the latest in a series of webinars from the Business and Property team here at St Philip's Chambers. My name is Harry Marriott. I'm a barrister in the Business and Property group, called in the year 2018. I'm kindly assisted on my left by Charles Towl. He is a pupil in the group. He is currently on his feet and he is taking instructions in all areas of the Business and Property group. Today we will be looking at the issue of forfeiture. This is, of course, an extremely broad topic. It won't be possible to cover every single issue that will arise over the course of this 1 hour webinar. Instead, what Charles and I hope to do is focus on some of the points of either broad application or particular practical significance. Now, probably the most basic question that arises is the question of what is forfeiture? Now, a commonly cited definition is that which is given in the case of Clay Lane Housing Cooperative Limited and Patrick. Quote, a right to determine a lease by a landlord if A, when exercised, it operates to bring the lease to an end earlier than it would naturally terminate, and B, it is exercisable in the event of some default by the tenant. Now, on that definition, forfeiture can, of course, arise in both a commercial and a residential context. Over the course of this talk, we intend to deal with both. Now, of course, we can't go into both of them in great detail, so what we intend to do is simply focus on some points which are particularly interesting in both. What is probably worth noting in that definition is the use of the word default. What is not said is exclusively breach of the lease. Now, of course, a lease can be forfeited where a tenant has breached an obligation within it, but forfeiture can also occur upon certain events happening that are specifically set out within the lease. So a common example of that, particularly in the commercial context, would be an insolvency event. Now, on a very basic level, the question of whether one of these things has occurred is a factual question. But before that factual question can even be considered, one needs to look at whether the covenant itself is actually enforceable. And I think that's a point that's often skipped over by practitioners, not actually being mindful of whether the covenant is enforceable in the first place. And if it is not, the question of factually whether it has been breached or not is an irrelevance. In terms of a brief structure of what we will be looking at over the course of this talk, we will be starting by looking at some of the covenants that can potentially give rise to forfeiture. Now, of course, we won't be able to consider every single covenant, and different leases will be drafted in different ways, but we'll be looking at some of the issues that will commonly arise and are likely to be of particularly broad implication. After we finish with that, we'll be looking at some of the restrictions on forfeiture. Then we'll be coming on to look at when the right to forfeiture may be waived. And finally, we will be looking at the court process surrounding forfeiture, and particularly we'll be looking at when the right to relief for forfeiture may arise. And at this point, I'll hand over to Charles.
Thank you, Harry. Now, starting with covenants of rent, this is perhaps the most obvious covenant that one might want to forfeit for. Obviously, it's forfeiture for non-payment of rent, but it also requires that the tenant has been made liable to pay that rent. So one needs to consider, well, has the tenant been made liable? A particularly interesting example to think about is long leases of dwellings. So in those cases, a tenant is only going to be liable for rent after the landlord has served them with a required notice that requires payment. This is in section 1661 of the Common Hold and Leasehold Reform Act 2002. I'll call it the CLRA. So before forfeiture for rent arrears can occur, you first need to require service of the rent notice. Moving on to what's required in the rent notice. The prescribed form of notice, well, that's information set out by the CLRA section 166, but also in the Landlord and Tenant Regulations 2004, Regulation 2. So starting with the 2002 Act, the notice has to specify the amount of the payment required, the date on which the tenant is liable to make it, and if that's different to what was required under the terms of the lease, the date on which you would have been required to make it under the lease. That's all quite straightforward information. Now, under the regulations, the notice must also specify the name of the leaseholder to whom it's given, the period to which the rent demanded is attributable, the name of the person to whom the payment is to be made and the address for payment, the name of the serving landlord, if that is different to the information listed in C, and his address, and then finally information provided in the notes in the schedule to the regulations. Now those are over slide in the additional information. So this is slightly different. It's all fairly straightforward stuff, but if sent by post, the notice has to be addressed to the leaseholder at the dwelling, unless a different address for service has been provided. And then secondly, this is one to perhaps note in relation to the date for payment, because that must not be either A, less than 30 days or more than 60 days after the day on which the notice is given, or B, before the date required by the lease. So essentially what that means is you need to give sufficient time after the notice is given, and it can't be before the obligation would have arisen under the lease in any event. Now, moving on to some potential issues with these types of notice. The first point, which is from Cheer Up Mate 2 Limited and Couse, which is an interesting company name to say the least. Minor discrepancies caused by using the old form of the notice are not going to be sufficient to invalidate the notice. However, obviously, if there are major discrepancies, so for example, if the prescribed information is not included, then that is going to cause an issue. The second point to note is as to whether or not a successor landlord can be held to have the same knowledge as their predecessor in relation to where the notice should be served. Now, the case on the slide of Obi Ezek Pazu says that they will not be imputed with that information. So if there's a successor landlord who has not been given a separate address for service of the notice, they're not going to be held to have the same knowledge as their predecessor. I think Harry's going to talk to us now about service charges.
So Charles has helpfully covered rent, which is obviously a very common issue that arises, non-payment of rent in leases, but it's probably also worth touching upon some other broad covenants that fall for particular consideration. In a residential context, the requirement for a tenant to pay a service charge is, of course, a common one, but of course, forfeiture based upon non-payment of service charges can only arise if the service charge has been properly demanded. Practitioners therefore need to be mindful of whether the service charge has been properly demanded and the statutory restrictions in relation to such when trying to advise their clients. Now, the main restriction to be mindful of is that which is at section 21B of the Landlord and Tenant Act 1985. That requires that the demand for the service charge is accompanied by a summary of the rights and obligations of the tenant of dwellings. And that particular information, precisely what information must be provided, is set out within the regulations of 2007, which appear on the slide. It is effectively a freestanding document full of information that all needs to be accompanied by the demand. So often, practitioners will see an inexperienced landlord purporting to demand a service charge from their residential tenant by simply issuing an invoice. If that is not accompanied by the information within the regulations, the service charge has not been demanded properly and the tenant is therefore not liable to pay it. So if you have a client coming into the office looking at forfeiting a lease on the basis of service charge demands and non-payment thereof, one needs to look at what has been demanded and particularly has that information been provided along with it. Repairing covenants are of course another covenant which is commonly giving rise to forfeiture events. Now, it is a particularly broad point of application with repairing covenants drafted in all manner of different ways depending on individual leases. But one thing which is probably worth looking at in particular is section 18 of the Landlord and Tenant Act of 1927. We will come on to discuss section 146 notices in a bit more detail shortly, but in respect of repairing covenants, there is a particular basis which needs to be complied with in respect of the 146 notice. It needs to afford a reasonably sufficient time to enable the repairs to be executed once the section 146 notice has come to the tenant's knowledge. So if it is a covenant that you are saying has been breached that requires particularly far-reaching works, if your Section 146 notice only gives a few days to complete them, it may well fall foul of this provision. So in a very broad way, we have looked at some of the covenants which are potentially relevant. But as we touched upon before, it is not only a question of whether those covenants have been breached, but practitioners need to be mindful as to whether the covenant is even enforceable in the first place. If it is not, of course, one doesn't then need to come on to look at forfeiture. Now, there are, of course, all manner of potential mechanisms which may render a covenant unenforceable. I've included just a few examples of that on the slide. So just briefly turning through a couple of those, looking at practical implications. Firstly, thinking about whether there has been an express agreement to discharge. A particular situation worth thinking about is landlord acquires a lease unaware of what agreements have been reached between the predecessor in title and the tenant. In a residential context, it might be worth thinking about the Consumer Rights Act 2015 and what effect that may or may not have upon the enforceability of certain terms. And it may also be worth thinking about whether a particular covenant is even possible to perform and whether they may be rendered void as a consequence of the same. Now, one thing which is often overlooked is the concept of whether a covenant has been waived by a failure to act by a landlord. There is a rather helpful summary in Woodfall, which I've included in full on the right-hand side. The question which is to be decided upon the facts of each case is whether the conduct or omissions of the plaintiff have put him in such an altered relation to the covenantor as it is manifestly unjust for the court to grant him the relief he asks for. The question is whether those omissions can be said to amount to a representation that the covenants are no longer enforceable. So in the broadest way possible, what we are looking at in relation to waiver of covenant is whether a landlord has acted in such a way that the covenant is not enforceable at all. Now, it's worth noting that this is a distinct argument of whether there has been waiver of the right to forfeit, and the two may be run in addition to each other or in the alternative to each other. But when we're looking at questions of waiver of covenant, the issue of forfeiture won't have arisen at all. We're effectively saying that the covenant is no longer enforceable and therefore it cannot have been breached. Now, this is, of course, a factual question to be determined on a case-by-case basis, so it's impossible to ascribe hard and fast rules. However, it's probably worth noting the need for the landlord to have knowledge of the breach. And this was a point that was particularly flagged by Lord Brown Wilkinson in the case of AG of Hong Kong and Fairfax, saying that effectively, before the question of abandonment of the covenant can even be considered, there needs to be knowledge. And that's probably worth stressing. This mere idea of acquiescence may not well be enough. A common example of where practitioners may want to think about that is perhaps in relation to a permitted user clause. So say, for example, that a landlord acquires a lease. The lease can only be done in the lease only allows the property to be used in a certain way. It turns out that the tenant has been using it in a different way for decades. It is arguable that if that new landlord is unaware of the breach, he cannot have been said to have waived the covenant, even if it has been the case that the permitted user clause has been being breached for decades. So on this point now, I'll turn back to Charles, who will look at Section 146 notices.
Thank you. So thinking about Section 146 notices, the first point to think about is what are they and when are they going to be required? And as I say, the first point is that a landlord may not forfeit a lease for breach of covenant other than non-payment of rent unless a notice has been served which complies with Section 146 of the Law of Property Act 1925. Now, this is obviously a restriction, and it's saying that the right to forfeit cannot be exercised in relation to the following unless the criteria that I've listed are met. So thinking first on the left-hand side about service or administration charges in respect of dwellings, this is covered by Section 81 of the Housing Act 1996. The first point is that it has to have been finally determined by an appropriate tribunal, court or arbitral tribunal that the service charge or administration charge is payable by the tenant. I think the wording here to focus on, and it applies equally on to the points on the right-hand side of the slide, is finally determined. We need to give some thought to what is meant by finally determined. If there's a judgment in default, for example, and the landlord turns up to the hearing to seek forfeiture, there may be an issue if the other side turns up and is granted relief on the basis of that. The other alternative is that the defendant has admitted that the charge is payable. Obviously, most tenants are going to dispute that the charge is payable, and so usually it's going to have to be the case that there's a finding in relation to that. Looking at the right-hand side of the slide, this is in relation to breaches other than rent, service charges or admin charges, and these are included in sections 168 and 1697 of the CRSA 2002 that we discussed earlier. Now, there are three requirements here, and they're broadly dissimilar to the ones just mentioned. And that's first that the FTT, the First Tier Tribunal Property Chamber, has determined that there has been a breach, the tenant has admitted to the breach, or a court has finally determined that a breach has occurred. Again, the tenant's not usually going to be willing to admit that there has been a breach, so we're looking at a determination by the tribunal or by an appropriate court. And again, that's the final determination, so that requires that there's no appeal outstanding or likewise. At the bottom there, I've noted that in both cases, the landlord cannot exercise the right of re-entry or forfeiture until 14 days, beginning the day after the date of final determination. And so it's always worth having those timeframes in mind. Now, moving on to the next slide, we consider what the process is. So on the left-hand side, we're thinking about what the notice has to require. And it has to include first, what the breach is, second, requirement that the tenant remedy the breach if it's capable of remedy, and third, that the tenant pay monetary compensation. Now, as Harry was saying, the period specified for the remedy has to be a reasonable period, especially in cases, for example, a repair clause or a breach of a repair clause. It has to be a reasonable period that's given. And then what the tenant has to do, or rather fail to do, is either remedy the breach in line with this, the notice within a reasonable time or the stated period, and they have to fail to pay the reasonable compensation. If both of those things are met, then the landlord can proceed with forfeiture. Now, it's useful to remember that the purpose of the Section 146 notice is to give the tenant that opportunity to remedy the breach or pay compensation. Forfeiture is obviously quite an extreme remedy, and so it's essentially giving the tenant every opportunity to do what they ought to have done already. Now, if we move on to the next slide, there's an example of what happens when the wrong breach is included within a notice. It's important to make sure that these notices are done correctly, because if you fail to comply with the requirements set out in 146 or the associated statutes, it's going to be invalid and give the tenants a lucky escape. In the example given, the Akiki case, the landlord had failed to specify what the breach was and had in fact specified an incorrect breach that the tenants had not committed. And so, lucky escape or landlord getting it wrong, well, we want to make sure we can get it right so far as we can. And so the main thing is to know what the breach is that's been complained of, and then making sure that that's set out in sufficient detail in the notice. An interesting point to bear in mind is where there are multiple breaches, the whole notice is not invalidated simply because some of those breaches are themselves invalid. So what do we mean by this? For example, if there's a breach of a rent payment covenant and that has been approved by the court, or it has been determined by the court, let's say, if that is included in the notice, but then something which has not been determined by the court is also included, the fact that the breach which has not been determined by the court is included does not invalidate the whole thing. That comes from the case of Panel and City of London Brewery Company 1900. Now, you'll see that that case is from before, it predates the 1925 Act. However, it is cited for this proposition by Woodfall at the paragraph given there, 17.134, and so it's reasonably safe to say that that proposition should stand. Moving on then to waiver forfeiture. Now, this is something that we need to be aware of because it is sometimes easily and inadvertently done, and so it's worth checking with the landlord whether they have done anything which might forfeit the lease. The starting position is that when a breach occurs, or when the default occurs rather, the landlord has to decide whether to forfeit the lease or treat the lease as continuing as soon as they are aware of the breach. Now, that decision is going to be binding and usually final on the landlord. That comes from the case of Central Estates Belgravia Limited, the third one on the slide. If the landlord has treated the lease as continuing, they can't then turn around and say they're actually going to forfeit it. That's really coming from the case of Matthews and Smallwood, that they cannot engage in inconsistent conduct. So they can't, for example, say, okay, we're going to forfeit the lease, but then continue to demand or accept rent. Moving on to the three elements of waiver, we're looking at having knowledge of the breach, committing an unequivocal act recognising that the lease is continuing, and then communicating that recognition to the tenant. So starting with knowledge of the breach, it's primarily an objective test. The intention of the landlord is irrelevant. If it's objectively clear that they knew what the breach was, they can't say, well, in actual fact, I didn't know. However, the burden of proof is always going to be on the tenant for this. That's set out in the Matthews case from the previous slide. And one point to note is that they can have knowledge imputed to them from their employees or agents. That can be sufficient. This is again the Central Estates case. However, to an extent, it depends upon the role that the agent is playing. If they are a full agent who is in the place of the landlord, that is clearly going to be sufficient. But if the position is more tenuous or it's not quite to that same extent, there may be a question around it. The final point is that simply constructive knowledge, and again, this goes back to the suspicion that Harry mentioned previously, it's not going to be sufficient just that they might have known or ought to have known. It has to be that they objectively did know or had knowledge imputed to them. The second point is the unequivocal act which recognises the lease as continuing. This is going to be a continuing act, or sorry, a positive act that the landlord has to commit. And in the brackets there, the most obvious example is demanding rent or further service charges. Again, a landlord cannot say, I'm going to forfeit the lease for this reason, and then continue to attempt to charge rent. But simply witnessing the breach that the breach has occurred does not amount to waiver. There has to be something which shows that the lease is in fact continuing. So if we move down and look at examples of conduct which amount to waiver, these are things which might be, for example, payment of rent by a third party on behalf of the tenant. If the landlord knows that there has been a breach and accepts the payment from the third party, that can be a waiver of their right to forfeit. Again, the slightly optimistic rent paid on a without prejudice basis to their right to bring a forfeiture claim, that's not going to work either because that's inconsistent with the lease having come to an end. And then finally, service of a Section 25 notice for possession is going to be conduct amounting to waiver because it shows that the landlord is treating the tenancy as having continued. However, it should be noted that service of the Section 146 notice is not amounting to waiver, as that is starting the process of forfeiture. The final element is that there has to be communication of the recognition to the tenant. It can't simply be that the landlord thinks this but does not communicate it. If there's no communication, there is no waiver. And then again, going back to suspicions or constructive knowledge, an understanding or belief on the part of the tenant is insufficient. That's again Central Estates. It has to be that the landlord communicates to the tenant that they are going to continue with the lease. Now, it's worth also noting the two types of breach which we can think about in relation to waiver. These are continuing breaches and once and for all breaches. Starting with continuing breaches, these are breaches which give rise to a fresh right of forfeiture every day the breach continues. So in relation to these ones, examples of these might include a breach of a covenant to keep in repair or a breach of a covenant to insure. The point is, every day that the property is not repaired or not insured is a new breach of that covenant. In relation to these continuing breaches, the waiver is only going to be effective for breaches prior to the waiver. So if breaches continue, after the waiver, fresh proceedings can be brought in relation to those. Additionally, it may not be necessary to serve a fresh 146 notice in relation to each continuing breach. This is a related idea in that if the breach continues, one notice should be sufficient to cover them all as they're all of the same type. The second type of breach is that of a once and for all breach. This is, as the name suggests, it arises once, therefore you should make your election when it arises. So the definition, I suppose, is that a right to forfeiture is lost upon waiver. Avoiding waiver is more important in these cases because once it's lost, it's not coming back. The rule of thumb that I put on the slide there is that if there's an obligation to perform an act by a given date or within a reasonable period of time, it's going to likely be a once and for all breach if it's not performed by the date given or within that reasonable time. Some examples of this kind of breach are a breach of the rent covenant. So if the rent is payable by a certain date and it's not paid by that date, the breach has arisen and the election needs to be made whether or not to forfeit. Again, breach of covenant is a similar one. And so breach of covenant not to make alterations is a similar one because once the alterations are made, the right to forfeiture arises and the election has to be made. And then finally, the breach of a covenant to carry out repairs by a given date. Now, moving on to the procedure for forfeiture, and subject to limitations, it proceeds by one of two methods. The first is going to be peaceable re-entry. Now, you first have to ensure that the right to re-entry has arisen, and that's going to arise from the tenancy agreement. It will be a matter of construing the agreement to see whether that right has arisen. Remember that Section 146 notices are going to be required if you're wanting to re-enter for any non-rent breaches. And the important thing to note is whether or not the property is let as a dwelling. So where it is let as a dwelling, the landlord isn't able to enforce the right of re-entry without order of the court. So they have to pursue possession proceedings. That comes from Section 2 of the Protection from Eviction Act 1977. And it's worth noting that this includes mixed-use properties. So if there's a property which is let as a dwelling, but then there's a commercial aspect to it, you're going to need to use the possession procedure. The final point is in relation to how do we characterise the act of re-entry. Now, the key element is that it has to be unequivocal. Merely securing the property is going to be insufficient. The kind of archetypical example would be to change the locks or to put a chain around open land to prevent access to it. Those are the kind of traditional examples of what peaceable re-entry would look like. Now, the other way of effecting forfeiture is through the use of possession proceedings. Now, again, it needs to be borne in mind that where property is let as a dwelling, this is the route that's going to have to be used. The first point is that where they are used, the lease determines upon the service of proceedings. That is the unequivocal act of the intention to forfeit the lease. However, the lease will only terminate upon judgment, although it's usually retroactive to the date of service. But what that means is that there's a bit of a twilight period between the service and final termination where the lease can, in some respects, continue. This is particularly at the fourth bullet point on the right-hand side, where the tenant can look to enforce the landlord's repair obligations during this twilight period, because they haven't agreed that the lease has been terminated and it hasn't been determined that it has terminated. This is given by the case of Peninsula Maritime Limited and Padseal. Following the issuing and the service of proceedings, because the landlord's position will be that the lease has been forfeited, rent cannot be charged after that period. Therefore, you're going to be looking at recovering mean profits for rent for the period of the continuing occupation after that forfeiture. Now, moving on to some procedural elements. The first point is that it is going to be governed by the familiar CPR Part 55. The claim is brought using the standard claim form for possession of property under Part 55. The claimant, however, something to note is that the claimant, as in the landlord, has to give the name of any person known to be entitled to apply for relief from forfeiture. That's pursuant to Practice Direction 55A, paragraph 2.4. So, for example, if there is a tenant who is known by the landlord to have an application or a possible application for relief from forfeiture, they need to make that fact known within their claim form and or particulars of claim. Another point to note, which is interesting given the increasing digitisation of court process, the claim form cannot be started by using the possession claims online process. That's in 55B, paragraph 5.12a. There's no reason given for that, but it may be simply that there's so much law that's accumulated over how this has to happen, it's easiest just to do things on paper for now. In terms of the hearings, the first point to be aware of is to consider whether or not the court has finally determined whether or not rent or service charges are payable. This is a point mentioned earlier. So if the time for appeal has not yet run, it's possible that the tenant could issue an appeal or make an application for permission to appeal, and that the court may be interested to hear how that goes before proceeding. If the judgment is a summary judgment or a default judgment where the issue hasn't been fully considered, so that should perhaps be default judgment, there's a risk that the tenant could turn up and say, well, grant me relief from forfeiture, they're granted relief, the judgment is overturned, and then the service charge or the rent has not been finally determined by court. Therefore, the forfeiture would not be possible in that circumstance. A second point, and this is perhaps more of a practical point, which has come from one of my cases a few weeks ago, is that judges are aware of how serious forfeiture can be. So if we're dealing with a residential case or a dwellings case, and the tenant turns up in person, they're often willing to give multiple chances to the tenant to ensure that things are done properly. In a case I had recently, as I mentioned, the tenant turned up with a load of documents we hadn't seen before, and the judge simply adjourned it off to allow time for those matters to be dealt with. So it can be quite a frustrating process, but it is important to bear in mind. Turning finally to costs, the general basis of assessment is going to be indemnity costs. That's set by Patel and K&J Restaurants at paragraph 40. And so that's quite a useful point to bear in mind for these hearings. An additional point, which is quite useful, is that where the lease contains specific provision for cost recovery, the court both can and should permit recovery of costs, even in small claims. And that comes from the Chaplair Limited and Kamari case. So both of those are quite important points to note, because assuming that the landlord is successful, they're going to be wanting their costs on the indemnity basis following the hearing.
So we have looked at whether covenants are enforceable. We have worked on the assumption that it can be found that they have been breached. We have looked at some of the procedural restrictions on the right for forfeiture. And then we've looked at how one may actually affect that, whether it by peaceful re-entry or by possession proceedings. What we're going to look at now is some circumstances where there may well be relief from forfeiture. And this is a very complex area, as there are effectively all manner of different rules depending on whether it is a rent or non-rent covenant that has been breached, and also depending on which jurisdiction that you are in relation to rent, with various different approaches. We'll come on to look at these in turn, but one should just be particularly mindful of the differences and remind themselves of these various rules. But first, if we just briefly talk about the effect of relief more generally, if relief from forfeiture is relevant, the lease will be restored and it will be as if the forfeiture has never taken place. A particularly practical point to have consideration to is any derivative interests from the tenant's interest will also be automatically reinstated. It should also be noted that it is only the court that can grant relief from forfeiture. So even if you're representing a tenant or a landlord and the other side of your case agree that the tenant should have relief, the consent of the court is still required. So you can't simply just agree it between you without the court having any involvement. We will go slightly out of turn compared to the slide that we were looking on the other side, and we'll first look at where covenants other than rent have been breached. And the principal jurisdiction for granting relief from forfeiture in such cases is now on a statutory footing in section 146 subsection 2 of the Law of Property Act 1925. You'll see on the right hand side of the slide there where what that says, and effectively it's a broad discretion to grant relief in circumstances that the court sees fit and on terms that the court sees fit. And it should be noted that the Hyman and Rose case, which slightly predates the 25 Act, but the point is still relevant here, that the court has a wide discretion as to when relief should be granted in such circumstances, and there has been a refusal to set down what are hard and fast rules about when to grant it and when not to. But as a very general principle, relief is likely to be granted in these non-rent cases where, firstly, the tenant has remedied the breach, or if the breach can't be remedied, paid compensation. That's working on the assumption that compensation is an adequate remedy. And secondly, the court considers that the tenant will perform its obligations under the lease in the future. Now, as I say, the court has never prescribed that as a hard and fast rule, but if you're advising a client and one or both of those aren't met, it may be a slightly good indicator as to the relative prospects. The case law has laid down a number of factors to be considered in relation to the exercising of that broad discretion. It won't be possible to go through every single one of those in the course of this talk, but perhaps if we just simply address some of the points which are perhaps of the broadest application. So firstly, the question of whether the tenant's breach was willful or deliberate. Of course, if it was those two things, it is less likely that relief from forfeiture will be granted. If the breach was caused by matters beyond the tenant's control, of course, that will make it more likely that relief will be granted. The question, we've already touched upon this briefly, is whether the tenant has made good or will make good the breach. And that perhaps links to the fourth factor, which is whether the landlord has occasioned lasting damage as a consequence of the breach. So perhaps a repairing covenant is a good point to think about there. If the repairing covenant has now been complied with and there is no lasting damage to the landlord as a consequence of that, those are certainly factors that will be pointed in favour of relief from forfeiture being granted. And then another point which is perhaps worth thinking about in particular is if there will be any hardship occasioned by the tenant if relief is refused. So an example of this might be a particularly specialised premises where the tenant carries out their business and perhaps the associated difficulties in relation to relocating. So I've had a few cases where there has been particularly important infrastructure in a commercial premises and the reflective implications upon granting relief from forfeiture in that context. Now, it should be noted, and we've touched upon this briefly before, is that under section 146, the court can impose conditions on the granting of relief from forfeiture. And those principally fall into two categories. So firstly, there may be an injunction prohibiting future breaches. That is probably going to be breaches such as permitted user clauses or particular repairing covenants not being maintained. injunctions requiring that that conduct is brought to an end. The second broad category is financial conditions, so looking at the payment of the landlord's costs, their expenses, damages, and any compensation. Now, in terms of the conditions, a tenant seeking relief will normally be required to pay the landlord's costs of forfeiture proceedings. Effectively, it is the tenant that has done wrong, and therefore the sort of logic behind that is they should be paying the costs. But just note this point that Abbey National Building Society touches upon, which is that if the landlord's conduct has caused an unreasonable amount of costs to increase, the tenant may not be liable for paying those. It should also be noted that if the conditions of relief are not complied with, the court can't force the tenant to do so. It simply won't be the case that the tenant gets their relief. So, for example, if it is an injunctive order as a condition of relief, the tenant doesn't comply with it, or you just don't get your relief, the court isn't going to start getting too involved in making sure that you do that which you should do. Just briefly having a look at time limits when we're looking at relief from forfeiture in relation to these non-rent covenants. And as Charlie talked to us, there's sort of two main differences in relation to the forfeiture. Is it by proceedings or is it by peaceable re-entry? In a case of proceedings, the tenant can apply for relief at any time until enforcement of the possession order. Practitioners will be aware of how long that can be, given the current delays in enforcement proceedings, so there's a potentially wide window there. And then secondly, in relation to peaceable re-entry, the tenant can apply for relief at any time, provided that it's equitable to grant that relief. A very obvious example there would be if there has been a huge delay in time, the court's unlikely to get involved then. So we have looked very briefly at the non-rent covenants. We're now looking at the rent covenants and where there has been forfeiture on the basis of non-payment of rent. Now, the court's powers here are very different depending on whether we are proceeding by way of the county court or the high court. We will spend the most of our time looking at the county court because relief proceedings in the high court are comparatively rare compared to those in the county court. And it should also be noted that, again, there are some differences as to whether the forfeiture has been obtained by proceedings or by peaceable re-entry. So looking at the county court, sections 138 and 139 of the County Courts Act 1984 now creates an automatic right to relief where forfeiture for non-payment of rent is by proceedings. And that is regardless of the amount of the arrears or the value of the property. And it's probably worth reading sections 138 and 139 in full, but it should be noted that it is it's a statute that's drafted in a way to create all manner of opportunities for the tenant to obtain their relief. So we have the first opportunity, which is under section 138(2). So if not less than 5 clears days before the hearing date of the proceedings, the tenant pays all of the arrears, interest and costs of the action, then effectively the claim ceases and the lease will be reinstated retrospectively. If you don't do that, there is then a second opportunity. So if at the first hearing the court finds the landlord is entitled to re-enter, possession will normally be ordered not less than 4 weeks after the first hearing date. So practitioners should note that when drafting their orders to submit in court proceedings, that sort of not less than 4-week period. But that order will also include a further opportunity to obtain relief if the tenant pays all the arrears, interests and costs by the date of the possession order. So again, when drafting your draft possession orders, there's plenty of pro formas online, but just make sure it's compliant with those provisions. But if we miss that second opportunity, there is then a third opportunity. So if the tenant does not comply with that court order, there is a further right to apply for relief within 6 months of the landlord recovering possession. And normally, and again, we're not prescribing hard and fast rules, but normally relief will be granted if payment is made of all of the arrears, interest and costs, and the court is satisfied the tenant will comply with their obligations in the lease in the future. So that's when it's by proceedings. Let's have a look at peaceable re-entry. We're still looking at non-payment of rent, in the case of peaceable re-entry, the tenant can apply for relief to the county court within 6 months of the re-entry, and the court, if it sees fit, can grant relief as if the High Court had. And we'll look at the High Court's powers briefly. We'll come on to this, sorry, forgive me, shortly. And it should be noted that this jurisdiction about granting relief by the county court in the case of peaceable re-entry for non-payment of rent is to be exercised in accordance with equitable principles. That links to the second point on the slide there, which is that the tenant must apply for that relief from forfeiture with reasonable promptitude. If the tenant delays, it's more likely that there will be intervening events to make it inequitable to grant relief. So, for example, landlord has peaceably re-entried, they may have granted a new lease to a third party. The longer you go on, the more likely that will happen, and the less likely it is that you'll be granted relief from your forfeiture. Just as a slight point of note, when the court is exercising its jurisdiction in these cases, it is not bound to require that the tenant pay all of the landlord's costs. Now, it's likely that that will be the case, but it's not a certainty. Looking then at the High Court, and as I say, we'll touch upon this more briefly, as this is a point that's perhaps of a little bit more narrow application. But Section 38(1) of the Senior Courts Act creates the power to grant relief in a summary manner when forfeitures by proceedings, provided that the tenant pays the rent arrears and the cost of recovering those arrears. Now, have in your mind this point of 6 months. If there are at least 6 months worth of rent arrears in such circumstances, and all of the arrears and costs are paid before the trial of the possession claim, the proceedings for possession are automatically discontinued. That comes from Section 212 of the Common Law Procedure Act 1852. Now, also note that that same provision allows a tenant 6 months after execution of a possession order to obtain relief, again on condition of payment of the arrears and costs. In the case of peaceable re-entry in the High Court, rather than by proceedings in the High Court, the court still has the power to grant relief under its inherent equitable jurisdiction. Now, the 6 month time limit to apply for that by Section 210 of the Act that we've just looked at doesn't strictly apply, but it will be treated as a guide by the High Court. Just very briefly, in respect of some practical considerations, if a party is intending to make an application for relief from forfeiture, they may well be well served by putting a notice against the landlord's title at HM Land Registry. That is an equity capable of protection by registration by virtue of Section 116. Similarly, if the application is then physically made, the same can be registered at HM Land Registry as a pending land action against the landlord's title. In that case, Section 34, subsection 1. Now, taking those steps may well help the tenant to argue that their original lease should take priority should a new lease be granted by the landlord before the relief from forfeiture application can actually be heard. As I say, it's just a practical thought that's worth doing. It may well create some protection. So with that, we bring this webinar to an end. You should, however, be aware that St Philip's is having a real estate conference on the 9th of October of 2025. It is a full-day conference. It is a session with a number of speakers and also an external guest. Hopefully it will contain a lot of content which is helpful to practitioners, particularly in the property field moving forwards. And I certainly would encourage anybody who's interested to sign up using the QR code below. It can also be obtained from our website. But thank you for listening to this webinar, and we hope that it's been of assistance to you.
Thank you.